Well, thanks for joining us today for the Nexa launch seminar. And we are very pleased and honored to have with us today two young scholars that are part of the Nexa galaxy for some time. I'm talking about Tommaso in particular. And Deidre Curtin from European University Institute and Tommaso Fia, University of Tübingen. We present today on cracking AI secrecy, migration law and governance, and beyond. This is a topic that fits very well the agenda of the Nexa Center, which has always been interested in exploring the interface between law and technology, new developments in digital technology and regulation, in particular the phenomenon of black box society, which I understand today will be explored in a particularly unsettling and I have to say creepy side, okay, migration law. So I'm very pleased to have you on board today, and without further ado, I leave you the floor.
Hey, thank you very much for this far too kind introduction. I realize that one of the many upsides of working together as a public lawyer with Tommaso, who is, I think he would still agree, a private lawyer or works on private law largely, is that I now get categorized as young. So thank you for that. Thank you, Tommaso. In any event, I am going to introduce the first few slides that we have to our paper. Perhaps we can go to the first slide because it's it gives. Can I do it or wait, we see? Okay, no. So who can do this?
Tommaso can do this. I don't know about you.
Right. No, I didn't share it.
No, I don't have control anymore.
Valeria can do it.
Oh yeah, now I can do it.
Yeah. All right. Great. Now you have control. Good. So this is what we're going to do essentially in the four. We have four different points, and I will present the first two, and Tommaso then the last two, and I come back in a little bit at the end. So I just wanted to say that also for us, in terms of writing this this piece, it's been a long and windy road. I think that's fair to say, Tommaso. We started working on it well more than a year ago, so it has not been a speedy or vigorous work. We have engaged a lot, but we were coming from different fields. And so a lot was to find commonalities and find the narrative, as we said many times, but also to give some evidence of what we were talking about, to be able to study it more empirically. And obviously, when you're talking about a topic of secrecy, that's not so evident how you study it empirically. So I think our idea was, well, an awful lot has been written about transparency in various disciplines and various contexts. And what we were really feeling is that actually the dominant rhetoric legally is actually secrecy, even though it is operationalized in long-standing legal rules on various kinds of secrecy. And so there is a kind of legal patchwork, both on the public side and the private side, that come together. I think we spoke about mingling at one stage. We weren't sure how common a word that was. But so we see, in fact, particularly in the digital arena a enmeshment between public and private approaches. And also in the AI Act, despite the rhetoric of transparency, you know, there are some references made to it, etc., and attempts to regulate, certainly for high-risk systems. But we felt that the dominant narrative in also the AI Act was actually secrecy. So when you explored and saw how central that was. So maybe we can go to our next slide. Yes. So why it matters, you know, obviously. So what we're seeing happening here is you've got something distinct, AI systems, you know, which is still relatively new. They are being applied also by public authorities. I think that was our interest as well, the way in which AI systems are applied by public authorities, often in sensitive fields that have effects on individuals and perhaps also vulnerable individuals. But AI systems in and of themselves, as I'm sure everybody in the room knows, are opaque, you know, both at, they suffer both from technical obstacles and epistemic challenges. So how do we, you know, fit this into our reasoning when it's being used by public authorities in the context of often unseen decision taking? So we defined, as you see here, AI secrecy as a legal architecture that enables public and private actors to keep AI development and deployment under wraps or behind closed doors. And basically, we're looking at secrecy as a phenomenon that is both intentional, it's deliberate, but it's also legal. It's regulated in one way or another by virtue of legal rules, and it's protected by those legal rules if there are challenges to it. You know, and I suppose where we were also jointly coming from is that these rules are now are challenging public accountability. They're undermining transparency as a prerequisite to any form of public accountability, because if you don't have information, it's very difficult to hold actors to account. And this permeates into also other spheres of supervision, etc., which you see where supervisors might get access to components of the AI systems that are used by, you know, public and private authorities, but they are then meant not to make them public and to give their reason giving in secret. So that is part of the background scenario. And so, yeah, part of what we're talking about is, and I suppose this is the lead in to the next slide, the double black box, the book by Ashley Deeks that has actually just come out, which speaks of the use of AI. It's in the US essentially, but it's the use of AI in, you know, the American national security context, and that, of course, national security in and of itself is supposed to be secret, but if on top of that you have AI systems being used, then you can talk of the double black box, and a metaphor that's been used in other contexts as well. Okay, we'll go on to the other slides. How am I doing? I think I have another 5 minutes. Exactly. Okay. So It took us a long time, I have to say. It took us quite some time because we started very much from what was known, in a sense, trade secrecy, and commercial interests, business interests, and getting access to information in that context. And then we later looked more at also public secrecy, so the use of professional secrecy, also other ways in which public actors can keep secrets, and particularly in the securitization context. At the European Union level, national security, there's no competence to get involved in national security as such. It's, from the very beginning was excluded from the competence of the European Union. But what we've seen happen in practice for many decades, actually before the Treaty of Maastricht, which was in the early 1990s, even in the 1980s, with Schengen, the advent of Schengen and the attempt to do away with internal borders for free movement of persons, there have been securitization processes going on. And so what we have today, in terms of actors and systems, there's a lot of what you might call legacy effects in that, and a lot of path dependency. Schengen database of the first one evolved into the second database, and then other databases were created over the years. Many of them you will, the visa database and Eurodac for fingerprinting and all of that. And then they were meant to become interoperable, which in a way has become a legal term as well. It was never designed as that, and is now regulated at the European level, but they were all made interoperable, or at least that is the trajectory. And a lot of also supranational actors, as well as what do they call it, boots on the street, police and border guards, etc. So yeah, and the problem in this area, there are a lot of actors, a lot of databases, but we don't actually know to what extent AI system are being used, or it's very difficult to get information. So part of what we do in this article, and part of the struggle in a sense, has been to get empirical evidence of what we're talking about. And I think we managed that actually pretty successfully. Maybe we can go on to the next page. I mean, we had to follow various sources. You had public actors such as the European Ombudsman, and there were investigations because complaints were brought by NGOs that they couldn't get access to information, and then you would you'd get some more information in that context. There wasn't little enough court cases, but there are a few which we also discuss, which are relevant. But you see that the actors, so we've given a list here, and it's a phenomenon we describe quite largely in our paper, is the involvement of private companies, and often the same private companies. So they're repeat players, and some of them have been repeatedly playing for quite some decades in different fora, and that has been really interesting to look at. We also looked at like procurement contracts, and have required information in that regard. And we were very lucky that a few weeks ago, a lot of our findings were also verified by Statewatch, which is a civil liberties NGO that does a lot of investigative work. And they had also gone through a strategy of trying to get access to information, and also established a pattern in that regard. I think I'm on my time is up, Tommaso, so I hand over to you on the next slide. So it is in this context that we have to think about how we conceptualized secrecy, which is really important.
Exactly. So just to make sense also of the vast material that we encountered when doing research on this, we realized that we needed to find a sort of valuable categorization to go about understanding AI secrecy. And so basically, since the very meaning, right, of this definition that we of AI secrecy that we give, that is like a multi-layered regime consisting of different legal instruments, contractual design, and institutional practices, we have three main actors in place here. So first, we have, of course, migration authorities that are those that are supposed to implement and to build the sort of migration governance tools in terms of operationalizing them and making sure that this works. Then private contractors that are, of course, from which systems, AI systems are procured. And then, of course, we have citizens and civil society actors that are sort of exposed to the working, right, of AI systems, and would also may want also to access related information on this. So the first categorization is between political secrecy and private secrecy. So this categorization is about the actor that can oppose and can sort of claim secrecy over an AI system. And so political secrecy is about public authorities that put it in place, so a migration authority. And then on the other hand, we have private secrecy. So basically the legal regimes that enable private actors, so in this case private contractors, to put in place some sort of secrecy strategy or regime. And of course, I will go into greater detail on the different legal regimes when presenting the following slide. But also to understand a bit better the essence and the nature of the different AI secrecy regimes that can be opposed, on which both public authorities and private actors can leverage. We rely on a distinction that was mainly made famous by Posen, by a government secrecy scholar, and his conceptualization relies on the distinction between deep secrecy from shallow secrecy. So secrecy is defined as deep when basically a small group of officials conceal its existence, so conceals the information, the existence of some information from the public and from other officials. So an apt description of this could be the expression unknown unknowns. So basically, the public doesn't know that some information is being deprived of some information from government or from a specific actor. And so in this case, this is an illustrative instance and example of this in the AI realm is, for example, the case that has recently hit the headlines of this AI-enabled murder prediction tool developed by the UK Ministry of Justice. This was developed totally internally, but then and so the public was totally unaware of this going on. But then the NGO State Watch, after some public access request, and also the Guardian, the UK paper, turned the spotlight on it. Right. So this is the logic of deep secrecy. On the other hand, we also have shallow secrecy. That is, those secrets related to AI that are more aptly described as known unknowns. So basically, when the AI development and use is by public authorities is known, but then the workings and the actual informational components of the AI are not known, right? And this is sort of the dimension of secrecy that the existing literature as mostly concentrated on. So there are different vectors and different strategies and legal regimes that pertain both to political secrecy and private secrecy. So in the case of political secrecy, we noticed that these legal regimes form and capture an idea of secrecy which is both that can be deep or a shallow form of secrecy. So on the one hand, a key enabler of deep secrecy is the public security exception that is provided in the EU access regulation. So the access regulation is that EU regulation that basically regulates access to public access to documents held by EU institutions and authorities. And so in this case, by relying on this public security exception, migration authorities such as Frontex have prevented researchers, journalists, and all other civil society actors from accessing even the basic information about the AI being piloted and developed. And another strategy that enables deep secrecy is the declaration by the public security, the migration authority of the contract, right, with the public, with the contractor on the AI developments, the declaration of secrecy. So there is a specific provision in the regulation that on EU authorities procurement that allows public authorities to declare a contract secret. So this can also be an enabler of the deep secrecy. In terms of shallow secrecy, we see that especially like in the way basically that also Frontex refused to provide information documents on AI-enabled drone accidents, or for example in public discourse when basically the use of AI by Frontex is always being hinted at, but downplayed, right? Like they never. Some years ago, Frontex was still very not very willing to use the term AI to designate some, to identify some specific algorithmic projects that were going on in migration. And this also comes to the fore even if we look at the AI Act, right? Because in the AI Act, of course, there are some transparency issues that are trying to be sort of sorted, and there are clearly some provisions that enable more transparency on AI tools, but the migration authorities and public agencies involved in migration can rely on different exclusions in terms of material exclusion, but also a temporal exclusion, like the public sector high risk AI system don't have to brought into compliance until 2030. So basically there is a sort of buffer period where the public authorities can act as they want. And then the Article 49 in the AI Act also provides this EU-wide database for AI systems, but the AI systems used in migration and law enforcement are placed in a non-public section of that database. So basically, this allows also, again, transparency to this, basically it means that transparency is, again, effectively hollowed out. And also this overarching Article 78, which covers any sort of actor that is involved in the application of the regulation, also basically binds all these sort of actors to maintain confidentiality, again raising the problem of political secrecy. In terms of private secrecy, here we're talking about basically the secrecy regimes that the contractors involved in migration governance can rely. These forms of secrecy, these legal regimes do not identify deep forms of secrecy, but more shallow forms, because it's not about the existence of the system itself, but about obscuring the inner workings, so the algorithms, the data involved, and logics involved by the contractors. So this is really important. This is really compelling, because virtually the vendor can also obscure and prevent access to this sort of information and data and algorithms, even to prevent also public authorities involved. But when looking at the contracts between the procurement contract between the public authority, the migration authorities, and the public contract and the contractors, we saw that actually many contractual clauses put the public authorities in control of the informational assets and the sort of algorithmic workings of the systems. So however, the private contractors can rely on different sources of secrecy. The most problematic being trade secrecy, which has a very low threshold of protection requirements, and on the other hand, it really relies on a broad, assertion, but by the alleged and by the alleged holder of trade secrets information. So there is no public decision involved in the initial, allocation of secrecy, of trade secrecy. Of course, there have been some cases. For example, the Parifarma case, and more recently the Dun & Bradstreet Austria case of the Court of Justice of the European Union, where basically this broad, overclaiming by private actors have been sort of countered, but still, this trend of overstate assertion remains. And there are also some other drivers of secrecy. If we look at the sort of factual secrecy that emerges in the contractual agreements between the migration authorities and contractors, but also in the very procurement procedures, because the applicable regime on procurements that applies to specifically to EU migration authorities and to EU public authorities and contractors really allows and sort of builds confidentiality around the information that the parties exchange in the specific case, in the specific procurement case. So this again really provides an additional layer of secrecy, and also this mirrors also the public security exception that we saw earlier on political secrecy. The access regulation also contains a commercial interest exception. So basically, the EU, the migration authority can also prevent access to documents held by them in case a commercial interest of a private actor is involved. And the notion of this commercial interest as being always interpreted as very broad, and in particular the need for transparency to overcome this exception, and so to make sure that to basically claim that there is an overriding public interest in disclosure of the commercial interest. So the need for transparency needs to be pressing on the one hand, and also more recently, the Breyer case, the court also highlighted that there is a need for demonstrating a sort of fundamental right violation in concreto. So in the specific case, this needs to be sort of demonstrated. So there are different, of course, transparency requirements that might come into play in the GDPR and in the AI Act, of course, to sort of counter private secrecy. But maybe we can go into detail about them perhaps in the Q&A session. But before concluding, I wanted to stress that in our paper we also see some, we try to identify, to single out some ways out of the enclosures of this green picture that we provided. So of course, on the one hand, there is need for reform, the legal reform of these regimes that allow, in some way or another, a very high threshold of protection of AI secrecy. But also we also look at some strategies, some countervailing strategies that might also come into play in the very fora where the decisions around migration take place. So, for example, now the consultative forum of that is meant to provide Frontex, that is meant to provide a channel for civil society engagement, is subject to strict confidentiality obligations, and so perhaps a higher degree of oversight can be allowed there. Also, the Frontex Industry Days, so events where public officials and prospective vendors meet to discuss the emerging technologies. Also here, the participation is very tightly controlled, and there is a formal registration system and also a careful vetting of participants. So perhaps also here, there might be some strategies here to allow and to open up a bit more public permeability to make sure that also, civil society, broader civil society is better involved and involved to a greater degree. And finally, the Frontex also maintains a transparency register of meetings between officials, senior officials, and vendors. This has been put in place to avoid any sort of obscure lobbying, being kept under wraps. But the content of these meetings still remains secret, so it's not really shared, the content of these meetings, in the transparency register. So we're left with a sort of form of transparency, but not really not really substantial, right? So this entire architecture, right, of AI secrecy also prompted us to think more about sort of more normatively about another possible notion of secrecy that we tentatively we tentatively named democratic secrecy. Perhaps, Deidre, you could expand a bit on this idea that we're currently sort of exploring, but we don't really deal with it at this stage on our paper. But it's a more normative idea of secrecy that we might also want to explore in the future.
Thanks. I won't say very much because I'm conscious that we've gone over time, and we're also very interested in having your feedback and what are the things that stand out to you or whatever. But, you know, our idea originally was to actually think, well, okay, what can be done about this situation? But as you see, we already have produced a very long paper. So it became impossible to do it in the context of this paper. But this is part of the agenda that we have, to think in terms of the broader questions. Also, I mean, it's too easy in a sense to say, oh, it's technology, it's technical, it's interoperability, you know, this is nothing to do with a more political debate. But, you know, there is also a politics to technology, and that is probably something we need to have a wider public debate about, whether it will be democratic or not, but at least the confines of secrecy, and there does of course need to be some secrecy, but what secrecy is justified in the public interest. So, you know, that's something we would like to engage on further in the future, but we've probably taken enough of your time now, so I think we'll leave it at that. Thank you very much.
Thank you very much. I did not take much of your time. I think we are pretty much on time to have some questions, to collect some questions from the audience. Before leaving the floor to the audience, let me just add a few comments on your presentation, which I found extremely interesting, especially the distinction that you made between the forms of secrecy. I think this is a very informative and guiding way of navigating the problems. I appreciate the fact that the issue on the issue of over assertion of trade secrets. You, Tommaso, you remember some cases of the European Court, where it seems courts are trying to be a countervailing power. So in the sense that they are trying to limit, okay, the exceptions. And one or other recent example is the New York Times versus Commission case about the famous SMS between von der Leyen and the Pfizer CEO, where the court, even though not addressing an exception for public security, but nevertheless insisted on a narrow interpretation of exceptions to the general rule that public interest should be preserved. And also on a personal note, you know, Tommaso, we carried out a study on trade secrets in the EU, and we have seen that also at national level, courts are very much reluctant to accept claims of that overclaim trade secret, and many litigations fail because the court is not satisfied that the plaintiff has identified a protectable trade secret. So this is one important point to keep in mind, that what is sometimes de jure or de facto called a trade secret might not resist a scrutiny before the judiciary. The other point I wanted to address is something that international lawyers are discussing extensively: the fact that migration issues are increasingly attracting under the umbrella of soft law and policies. In fact, we speak of migration policies, not migration law. So, and policies and soft law is sometimes is the way of adopting practices that would be otherwise not legal, in the sense that they if translated into law, they would be either unconstitutional under national law, or they would go against fundamental rights. And of course, here I'm referring, the debate is mainly about the fundamental rights of migrants. Okay, but maybe these, I wonder if in your research you have come across this problem of the way in which policies are shaping the framework and the architecture in a way that makes that in a way that certain actions become policy compliant, but maybe not necessarily legal compliant in the sense of the fundamental rights. And as to your last point, the democratic secrecy, well, I would like very much to know more about it. I understand that this is mainly a suggestion that you make for further development, and I think there are two main issues with this. One is the one thing that you mentioned, the exclusion in the AI Act for AI for military purposes. So there is a risk that given that practically 99% of AI is so-called double use, that it is enough to brand something as a public security just to avoid completely the AI Act as a regulation. So here the risk is really not just we are not speaking of an exception to the rule of public access that can be then construed narrowly by courts, but here we are excluding altogether regulation. So, and I wonder what the countervailing measure could be. Of course, we are speculating because we will see this in the next years, but and whether democratic secrecy has to do also with this. So on making sure that AI does not escape transparency obligations simply because it is branded military or defense or national security. National security now is such a broad and all-encompassing concept that includes pretty much everything. So I don't know if you want. Mine were more comments than questions. So, and again, I appreciated very much your presentation. So I don't want, if you know, I don't know if you want to react to these comments, or we can also invite.
We can do brief. Well, as you prefer. We can also gather, or as you prefer, or we can very briefly. But again,
yes,
we want
okay.
to
Just
leave time to hear
yes,
others.
and then I see that Ludovica has booked the question. Yes, please.
I would just say maybe briefly, Tommaso, if I could. So on the trade secrecy, not being a private lawyer, but I do see that there is a shift also in the response of courts in terms of over-assertion. But of course, that requires actual litigation in the first place, and expensive litigation, you know, in possibly various higher courts. And I think in the vast majority of cases, it's simply, you know, will be used by the public authority to say, oh, well, there is a private interest here. Certainly, even in the context of the public access regulations at the European Union, that's what they do. And if you look at also European Ombudsman investigations, which we have done quite extensively, the public authority simply, you know, has asked the private provider, and they don't want to give it because of, you know, however they frame it, commercial or business secrecy, and that is considered acceptable. You know, your two other questions, there weren't questions, as they were comments, but they're fantastic. And I think the issue at the European level, so yes, soft law does play in, and there have been some instances of that, and then that can be challenged before courts and stuff like that. But I think what is far more widespread is the fact that at the European Union level, there is a system of migration governance. So I wouldn't even say it's governance, you know, it's actors who are just a database that and that has spread, also of composite governance. So it's not just among the supranational actors, but it's including national actors on the ground. But it's very difficult to make it visible and seen. So that is really the sort of the way in which securitization is really becoming very prevalent at the European Union level. But it has been going on for a long time. It's not a new thing either. It's just been built upon progressively. I love your comment on, I'm not going to take up any time at the moment on democratic secrecy, but the double use technology, because that's actually something that the civil military that you see has been done a lot at the European Union level, but it's hidden. And it is, again, it's beginning to come out a little bit more, the evidence. So I think what's really important is that there is also some public debate, but, you know, it has to be known in some way, shallow secrecy, as we would say, for something to be done with it. So the first stage is always shallow secrecy, even if it's not known exactly what it is, but enough in order to be able to challenge it in one way or another. And perhaps not only through courts. That's also not realistic. I'll leave it at that. Thank you.
Thank you. Tommaso, you want to add something, or?
I mean, I think, I mean, I agree with everything that has been said. Thanks so much for Mauricio, for your comments. Fantastic. And yeah, I totally agree. Also, as Deirdre just said, also trade secrecy is especially problematic in terms of the first mover advantage that the putative holder has, right? So of course, ex post, courts will be reluctant to validate the trade secrecy claim, but the problem is that at the very beginning, like the initial act of allocating a trade secrecy claim is upon the putative holder, and there is no public decision about it. There is no public authority that is involved, as you know is the case in the patent legal system, right? And so that is very problematic. And even if a trade secrecy claim is not validated, then there are other forms that sort of are layered in. So factual secrecy in the contracts, and also the exception, the commercial interest exception in the access regulation is not totally aligned with the idea of with the concept of trade secrecy, and so it's broader, right? So it covers also confidential information that doesn't qualify as a trade secret. So I think that the you know, what is really striking is that there are all these plethora of different you know, legal regimes that apply at the same time, and it's very hard to find you know, countervailing strategies, right, to bypass them and to sort of open up access to information. And as to democratic secrecy, and I will be very brief, we explored, I mean, this idea was, initially we explored the idea of basically applying a sort of deliberative democracy lens to this. So basically trying to build the participation of different publics. So not just the private actors and the public actors involved, but also civil society and individuals affected by a system to begin with. But of course, this is something that we wanted to explore, but then we sort of left out of the scope of the paper, which is already quite substantial and broad. So, but perhaps, we would be curious to listen to Ludovica's question.
Yes. Ludovica, please manifest yourself.
Yes, sure. I'm trying. I don't know if you are able to see me. Okay, fantastic. Thank you very much for your presentation. It was extremely interesting. So thank you very much. I was quite interested in the reconceptualization of AI secrecy you developed. Well, you identified this distinction between political and private, deep and shallow. And I was wondering if you experienced some difficulties, or if you had any issues in identifying in the interplay between public and private when these two sectors overlap, in this gray zone between public and private. Because you at some point, looking at the political secrecy, you mentioned the obligation to access some obligations for public sector to access information. And I believe that, for example, in that context, it's quite relevant to identify the legal status of the actor involved in order to understand the kind of obligation the actor has. So, and I'm working on the concept of public interest in EU politics of data, and I'm experiencing some difficulties in identifying this gray zone between public and private, this strong interplay, let's say. And there are scholars that argues that the distinction, the very traditional distinction, public-private doesn't work anymore, that it's not suitable anymore. And I don't believe so. And I believe that the analysis that you propose is an example that's, I mean, it identifies, it reveals the relevance between these two, the distinction, and probably it underlines the problematic aspects at the basis of this distinction. And to some extent, I believe it's related to what Maurizio said about dual use or AI Act for military sector. So I don't know, I was wondering if you had these issues related to public-private interplay.
Yeah, if you want, yeah.
Or you can go first. I don't. It's we have encountered that, but again, there it's hidden, because of course you have it at a very basic level when a public authority is using a system that has been developed, and procured, etc. So you have it at that level. But then if access is sought to the information, they simply rely on the exceptions, that were conceived 25 years ago that have nothing to do with data. And I think we say it at one stage, and that was really struck us quite a lot, was how this public security is public interest, also in the wording of the access regulator. So that's, the mantra, and there is no consideration, no room for consideration what a broader public interest might be other than public security, other than the argument that has been given by the public actor on security. And in that discussion, there's also the private inside it as well, because, you know, we are talking about public security that is, to a large extent, being privately provided. But, you know, the problem is that there has never been animo to even rediscuss having a new version or one more adapted. I mean, maybe what we need to think about is the need for a new regulation, so not soft law, on data and on access to data. And in that context, you could have a more confined discussion. But, you know, the old access to documents regulation, which is a source of some of the openings that you get also by NGOs and that, it really is written in stone at this stage and very ill adapted to the kind of phenomena that, you know, we're dealing with and the kind of considerations that there should be there. But I find your work on conceptualizing public interest really important in the context of data sharing, all of that. So if ever you would like to come to the EUI and present it to our researchers, we have a working group on that. That would be really nice. I don't know, Tommaso, would you like to add something to that?
Yeah, actually, thank you very much for your question, Ludovica. I think it's extremely relevant, and we did struggle a bit with this with distinguishing between, you know, the public actor involved or the private actor involved, and this dimension of struggle was very much present when we, for example, look at how the you know, the GDPR and the rights of the data subjects right would come into play here, because according to the GDPR, of course, Article 15 and 22, basically the data subjects would have a right, you know, to access the, you know, meaningful information about the logics involved and so forth. But the problem is that here the in migration, in the migration context, in migration governance, the actor that qualifies as data controller is not the private contractor, but the public authority, right? But the public authority in many cases is not, you know, sometimes is even you know, deprived of some information that might be relevant to be disclosed to the data subject, right? So I think here, like, data subjects, individuals face the challenge of whom should they refer to their access request, right? And so here you can really see the struggle, you know, between also identifying the relevant actor from which you would like to access information to, you know, to make to you know, to be empowered and to make a sort of rational decision based on this. So I think this is something that is totally relevant, and also it emerges really again from how the migration authorities with their private counterparties also structure the governance system. So I think it's really about how in the procurement procedures and how basically they can also allocate and sort of distribute the roles and tasks between between them. So at that level, it's really, you can really understand that the distinction is really blurry. Like, you can't really make sense of who's doing what and who should should be should be asked, should be subject to a sort of request from affected individuals and other actors that would be interested also in having access to information. So yeah, I think it's very relevant, and I hope we answer to your question.
Thank you.
Thank you very much. Thank you, Tommaso. Thank you, Deidre, for this fantastic presentation and for your fantastic work you're doing on this very, very, very sensitive and important topic. I'm sure we will continue this conversation. I hope this is just the start of a conversation about on these topics. And good luck with the continuation of your work, and hope to see you soon in person and to continue to discuss this topic. Thank you again.
Thank you very much, Maurizio.
Thank you for inviting us.
Yeah, thank you for inviting us.
It's the first time that we've actually presented the full paper, so go ahead, Tommaso.
No, I just wanted to, yeah, exactly. I think this was the first time we presented the final draft we have. And yeah, thank you very much, Maurizio, again, and thank you, Valeria. It was fantastic. Okay. Yeah.